Good morning and welcome back to Federal and Indian Gaming Law. Just to kind of recap where we've been, talking about Indian gaming, sort of just a general overview. Again, we'll have guest speakers to lecture about specific topics. There will be specific reading assignments for those guest speakers. The materials that you have are good base materials. At least skim them, have some understanding. I think it would be helpful. Again, tribes have had a long history with the United States government and state governments. Again, during colonial times, the British Crown reserved the sole right to interact with tribes. Constitutionally, the federal government has the exclusive power to regulate commerce with foreign nations among several states and with Indian tribes. I think it's Section 8 of the Constitution, Article 8. We talked about Johnson v. McIntosh, where that discovery doctrine comes about. There's a follow-up case in the Marshall Trilogy called Cherokee Nation versus Georgia. In this, we get the notion that Indians are essentially wards of the state. The relationship between the United States government and tribal governments is one of a domestic dependent nation, where the U.S. is sort of the guardian and the tribes are wards. Then we have Worcester versus Georgia, following up on that, and that confirms that states have no land claim rights to Indian lands. Back to that discovery doctrine, Georgia argued that it was the successor in interest to the British Crown when it declared independence from Britain. The federal government said no, the federal government is the successor in interest, and that sovereignty was inherited by the federal government, and the court confirmed that the federal government was the sovereign over inherited ownership rights. And again, that discovery doctrine basically says that tribes have no land ownership, the federal government does, but tribes have a right to occupy the land. So continuing on that, we had those multiple eras: the coexistence era, the removal and reservation era, the assimilation and allotment era, the reorganization era, the termination era, and then the self-determination era. And that's currently the era that we're in. The self-determination era was ushered in during the Kennedy years, came into being in 1961. It reaffirmed tribal sovereignty and governance. It recognized the impoverished nature of most tribes. Again, tribes were moved from good land to bad land, often moved into undesirable parts of the country. And as such, the federal government funded tribal nation building by funding tribal institutions. So the federal government would fund education, healthcare, police for tribal governments. Of course, a change occurs sometime in the 1980s. So you have the Kennedy years in the 1960s, where it reaffirms tribal sovereignty, tribal governance, recognizes that the United States has some obligation to fund the building of tribal institutions, and funding continues to flow from the Kennedy years through the Johnson years, through the Nixon years, through the Carter years. I guess I forgot the Ford years in there. But during the Reagan years, the doctrine was changed a bit to be also not only self-determination, but self-economic development. And tribes were encouraged to engage in their own economic development. And in response, the federal government cut funding for a lot of tribal government institutions and services. Now, at the same time, back in the, during the self-determination era, there were still concerns about the limited ability of tribes to actually enforce criminal laws on their land or on the land that they occupied. Despite being sovereigns, again, being disenfranchised for decades and decades and decades, left tribes with few resources to actually fund or operate government and provide government services. So what Congress did in response to avoid having pockets of land within states that were essentially lawless is they permitted certain states that had substantial reservations within the state borders to enforce state criminal laws on tribal land. And again, the idea was to prevent tribal lands from being used as pockets for illegal activity. And in a lot of cases, it was there to protect tribal members. So again, with this backdrop, you get tribes looking for some way to develop economically, often having land that is not fertile, not great for farming, not great for mining, although some tribes do have land that was good for mining. Most didn't. And, in some cases you had tribes with land that wasn't contiguous. So they had these little pockets of land throughout a state. So some tribes engaged in operating or licensing gambling on Indian lands, primarily bingo, high stakes bingo. And those PL 280 states sought to enforce state limitations or prohibitions on bingo on tribal land. And we saw that turned out with Seminole v. Butterworth. Again, the state of Florida limited bingo to low stakes bingo to be conducted by recognized charities, and thought that what the Seminoles were doing was illegal by licensing out the operation of a bingo hall with high stakes gambling. In addition, the building had issues, and the gamblers were not tribal. They were coming onto tribal land from the state of Florida. And the court said, no, if the state can regulate bingo, the tribe can regulate bingo. And that the criminal prohibition on bingo or large stakes bingo or bingo by anybody other than a charitable organization was primarily regulatory, not prohibitive. And eventually we get to Cabazon v. California. Again, here the Cabazon Band of Mission Indians operated a bingo hall and a card room on tribal land in Riverside County. Riverside County sought to shut it down and actually did shut it down. The tribe filed for deck relief. The state of California got involved. Eventually it ends up at the Supreme Court. And the Supreme Court said that tribes can regulate gaming in the same manner that states can regulate gaming. Now, two views of this, or two interpretations of this came out. Many tribes had the view that this was an unfettered right to offer gambling on tribal land. States viewed this as a tribal right to regulate whatever forms of gaming the state permitted or regulated. So a little difference of opinion there. Either way, it caused a lot of concern. So everybody runs to Congress. And primarily the states go first, and they want to protect their citizenry from pockets of casino activity with limited or no oversight. Again, most tribes were still impoverished. If you take a look at the Seminole experience, the folks that were operating that initial bingo hall had questionable ties to criminal activity. These weren't exactly stand-up citizens in many cases, but from the tribe's standpoint, it's found money. They don't have to invest anything, and they're getting paid something. And they really didn't have access to capital the way that commercial operations would. So, they had to deal with whoever they could deal with. But states were appalled by this. So states ran to Congress, and they were appalled by the thought that tribes could regulate gambling any way the state could regulate gambling. So again, you had that case out of Wisconsin where a crafty lawyer said, if the state can offer a lottery, then we can. and the state didn't really oppose that. Then he said, well, what is a lottery? Well, it's a game with consideration, chance, and prize. Consideration, pure chance, and prize. And there are other games with consideration, pure chance, and prize, like slot machines. And the state wasn't too happy with that idea. So states ran to Congress for protection. The tribes ran to Congress to protect the hard-fought gains that they won, or I shouldn't say they won, but that were confirmed to use gaming as a tool of economic development. Law enforcement had issues. Law enforcement was concerned that organized crime would infiltrate tribal gaming and tribes in general. Again, if you learn from the Nevada experience, little regulation, no regulation, and ineffective regulation led to exactly that. So law enforcement had their concerns, and tribal groups wanted to ensure that tribes actually benefited from gaming and weren't exploited by wealthy developers. Again, going back to that Seminole experience and some other experiences where developers came in, they built a building, they ran the operation, they gave the tribe a little money. The tribe had no rights other than to collect that revenue. But the tribes signed these deals because they just didn't have bargaining power. They didn't have economic power to bargain. So there were tribal groups that were interested in tribal welfare. They wanted to make sure that the tribes were the primary beneficiaries of gaming. So in response, Congress does pass IGRA. And IGRA, the Indian Gaming Regulatory Act of 1988, again, 1 year after the Cabazon opinion was published, established a federal regulatory body and regime for regulating gaming on tribal lands. Established the National Indian Gaming Commission, the NIGC. It created a grand compromise between the competing needs of or desires of states, tribes, and those that were looking out for tribal welfare. And it defined the state's role. So again, kind of picking up where we left off, Class 1, Class 2, Class 3. Class 1, traditional social gaming. Minimal value gaming remains the sole domain of Indians. Class 2 is bingo and bingo-like games, and non-house bank card games if the state permits those games elsewhere. Expressly does not include bank card games and slot machines. Then you have Class 3, which is all forms of gambling that are not Class 1 or 2. So Class 3 is the catch-all. And each class has differing levels of state or federal involvement. So again, Class 1, we discussed this last time, but again, the thought was to preserve gambling in the social context that is part of tribal custom and ritual and celebrations. And again, tribes can do this without any influence from the state or the federal government. Then Class 2 becomes bingo. And I did get one email about bingo saying they weren't sure how bingo worked. So let's watch a really short video.
Bingo is a fun and exciting game of chance that is extremely easy to play. Simply take your bingo paper, your ink dabber, and get ready for the numbers to be called. A bingo caller will pull the balls that are drawn out of the hopper and call out the number to be dabbed on your paper. Prior to the start of the bingo game, a game pattern to be played is determined, which can be anything from 4 corners, 5 numbers in a row, or even a full card. Numbers are called N31. When cards are marked and the first player to complete the specific game pattern wins. For more information on the game of bingo or to view bingo products, head over to arrowinternational.com.
That help? So yeah, traditional bingo operates exactly like that. You have a ball hopper, you have balls with numbers and letters on them, you call them out, and the players have bingo cards, often sheets sort of usually on newsprint quality paper, and they daub or dab ink onto each number letter combination that they have that's been called. And the first person to stand up and yell bingo for achieving the pattern, either 5 in a row or diagonally or the 4 corners or the whole sheet, wins whatever the prize is for that game. So Class 2 bingo can be played on Indian lands within the tribe's jurisdiction, provided that the state permits gaming for any purpose. This is charitable gaming, lottery, horse racing. If the state has any of those things, then tribes in those jurisdictions can embark on offering Class 2 gaming. Now, the tribe's body has to adopt an ordinance permitting Class 2 gaming. And again, Class 2 gaming is bingo, lotto, pull tabs, punch bar, jars, things like that, things that are similar to bingo, and non-house bank card games if the state permits them. Now, again, I don't know how many of you are from California or familiar with California, but California does regulate card rooms. I don't know if anybody here is from Minnesota. Minnesota also does that. That means that tribes in those jurisdictions can run games like poker as Class 2 and not Class 3 gaming. States like Wisconsin, for example, do not permit playing card games for money, or don't permit non-house bank card games like poker. So that becomes Class 3 gaming for tribes in that state. That makes sense? Basically kind of following that line of thought in Cabazon and in Seminole, where if the state can regulate it, so can the tribes. In this case, if the states do regulate it, then so can the tribes. Excuse me. Sorry, swallowed the wrong way. Tribes, again, must enact an ordinance that provides the tribe has total control and interest over that gaming operation. There was grandfathering for operations that were already in play at the time IGRA was enacted. Some of those operations did not put the tribes in control. But going forward, the tribes had to have total control and interest over the gaming operation. It limited the use of net revenues. So it could only be used for tribal government operations, general welfare of the tribe and its members, economic development, donating to charitable organizations, and funding local government agencies. By the way, that can also be local government agencies off tribal land. And what you see in some locations are that tribes and local governments are close. So for example, you might have a tribe with a small piece of reservation land. It operates a bingo hall and it enters into an agreement with the local government off tribal land to provide things like fire service. So, if there's a fire at the bingo hall or on tribal land, the county fire department will come and put it out, even though it's technically not within the jurisdiction of that local government because it's tribal occupied land. And they do this, sometimes with police services, health services, ambulances, things like that. So it really has helped knit a close community between tribes and the local jurisdictions around tribal land in a lot of cases. Not every case, but in a lot of cases. Again, the tribe's ordinance must provide for annual audits to be provided by the National Indian Gaming Commission, the NIGC. Any contract over $25,000 has to be subject to an independent audit. Facilities have to be constructed and maintained to protect the environment and public health. Yep, tribes have to have a system of background checks for licensing managers, standards for licensing, and notification to the NIGC of licensees. The NIGC can then also do its own investigation, consult with law enforcement, and it can object to the license of any individual. Again, this kind of goes back to that law enforcement concern about having bad people infiltrate tribal gaming and tribes themselves. On to class 3. Again, class 3 is anything that isn't 1 or 2. So, sports wagering is a good example of class 3. This was debatable for a long time. There were some crazy debates that sports wagering was in class 3, but it's not class 1. And it's not bingo. And class 3 is a catch-all. So yeah, sports wagering is class 3 gaming. There were some arguments it was class 1. I don't know any tribes that were betting on the NFL in ancient times. So, or as part of their tribal customs. But anyway, class 3 can only be conducted on Indian land if authorized by an ordinance or resolution by the tribe. It is approved by the NIGC chairman. It's located in a state that permits gaming for any other purpose, and it's conducted in accordance with the tribal state compact. Here's where the state's role comes into play. The tribe and the state have to enter into an agreement. And anytime you enter into an agreement, you're going to have to negotiate. And you're going to have to give up something you're going to have, in order to get something else. So the tribal ordinance must be as detailed as the class 2 ordinances. They have to be approved by the NIGC chairman, although the NIGC chairman's hands are tied unless they can show that it wasn't properly adopted by the governing body or it was significantly or unduly influenced by unsuitable people. Again, early investors in tribal gaming often were unsuitable, but IGRA aimed to clean that up. Again, with regard to the state conducting some form of gaming activity, it is any kind of gaming activity. So again, that Lac de Flambeau case, games consisting of the element of consideration, chance, and prize are sufficient. There is a process for compacting. The tribe requests to enter into negotiations with the state. Now, IGRA says that the state must negotiate in good faith. But a second Seminole v. Florida case said they don't. And we'll talk about that in a little bit. But if you remember, that other case was Seminole v. Butterworth. Butterworth was the sheriff of Broward County, Florida. The sheriff went to law school and eventually became the attorney general of the state of Florida, and he sued the tribe again. The compact has to apply or has to provide for the application of state or tribal criminal and civil laws, so defining whose laws are going to apply and how. The allocation of civil and criminal jurisdiction between the state and tribe. Again, there are some tribes that will turn over, for example, some law enforcement activity over to the local authorities nearby. If you're a small tribe, you may not, especially initially when you engage in gaming, you may not have a full-time police department. But the county has a sheriff, and often the cities nearby have police, so you can enter into an agreement to pay for those services. It should account for the state assessment of costs incurred. Taxation by the tribe at a rate comparable to state rate is kind of again, this is all about nation building. The money goes back to the tribe. Remedies for a breach, standards of operation and licensing, and any other subject directly related to gaming operations. Now, for example, in many states, vendors have to be vetted not only by the tribe, but by the state as well. You see this in California, you see this in Arizona, you see this in a lot of states. Not every state, though. Not every state has a state gaming investigative body, but Some states do. In California, it's located within the Department of Justice there. The compact has to be approved by the Secretary of Interior, and they have to approve it unless it violates IGRA or some other federal law. It's clear in IGRA that this does not give the states the ability to tax tribes for Class 3 gaming. Again, tribes are essentially co-equal sovereigns with the state. They're subject to federal oversight, but tribal government is, I guess a simplistic way of looking at it is tribal government is on par with state government when you're looking at sort of that level of government. Now, what states can get are exclusivity payments. And early tribal state compacts didn't have these, but somebody got really brilliant and said, you know what, we can't charge a tax. But what you can do, tribe, is you can pay us, state, for not authorizing any gaming activity, commercial gaming activity within a particular radius of your tribal gaming operation. And for that, we'll take a fee. Now, initially, for example, in California, it was 25% of gross gaming revenue for a 35-mile zone of exclusivity. That's been challenged, by the way, and found to be a tax. So the level has come down substantially in California, but in other states, it's still pretty high. And for most tribes, they've deemed that it's worth it. If you're, for example, in California, let's say you're in the San Diego area, there are a couple of tribes there that have casinos. What would happen to your casino operations if the state of California decided to allow a casino in Mission Bay? Anybody familiar with the San Diego area? You know where like Pachanga is? Is that right in the city? Anybody ever been to? It's not. It's out there. Mission Bay, that's kind of like a pretty nice area. A lot of population around it. So from the tribal perspective, it may be worth it to make sure that there's no competition within a certain radius, because often the location of these casinos is not in the most populated area of the county or the state. So you don't want a more convenient gaming operation being available. Again, the regulations have to include that, or I should say, IGRA doesn't impair the rights of the state to regulate gambling concurrent with the state. The regulations enacted by the tribe have to at least meet the standards detailed in the compact. There will be a tribal gaming commission, tribal regulations. Now, that doesn't mean they're going to be online. If you're ever doing research in this area, not everything is available online. It can be difficult to find. Some things are published in the Federal Register, but often the scans that you get are super low quality and they're unreadable. It has to account for auditing of casino operation and cover law enforcement efforts. Again, states are supposed to negotiate in good faith pursuant to IGRA, but Attorney General Butterworth sued the Seminoles, saying that the state doesn't have to act in good faith. And what was the argument? Well, the argument was states are sovereigns, and the federal government can't compel states to act in good faith when they negotiate. And the Supreme Court said, yeah, you're right. That's an excessive use of federal power. Congress does not have the power to tell states that they have to negotiate in good faith with Indian tribes regarding gaming compacts. However, there is a workaround, and it's worse. And so far, this has been upheld. And what happens? Well, if the state asks you to negotiate good, or the tribe asks the state to negotiate good faith, and it says, go pound sand, we're not talking to you. The tribe can submit a written request to the Department of Interior. And the Department of Interior will then decide, will request that the state offer its best offer for a compact, tribal offer its best, and then the Department of Interior, the federal government, can just impose a compact. Nobody wants that, so everybody negotiates in good faith. Class 2 versus Class 3. Why is this important? The distinction? Because no state compact is necessary for Class 2. And if there's no compact, there's no revenue sharing. So from a tribe's perspective, Class 2 is preferable. However, bettors like Class 3 devices better. Back to life. So tribes are always looking for, and manufacturers of bingo systems are always looking for ways to make bingo more attractive. And what you're seeing off to the right there is a bingo machine. Remember, bingo includes playing bingo with a technological aid. That is a technological aid. If you look really closely, you'll see a bingo card in the upper screen. It's actually a bingo game that's being played fast. And then what you get is that entertaining display down below. Bingo. But again, there are some limits to the creativity that you can employ to keep a game bingo. Here's a good example. Now that we all know how bingo is played, here's a game called Quick Shot Bingo. Once a week, a person at the Golden Eagle Hall draws 5 B numbers, 5 I numbers, 5 N numbers, 5 G numbers, and 5 O numbers from a bingo blower. The numbers then posted on bingo number boards located at lots of facilities on the reservation. To play the game, customers purchase a bingo card for 50 cents each at those locations, and then they can compare the numbers on the card to the numbers that have been drawn. And if the numbers on the card correspond to the posted numbers, they win a prize. And the prize is predetermined. So what do you think? Bingo? Not bingo. So you walk into a gas station on tribal land, there's a board, it's got the 5 B numbers, the 5 I numbers, the 5 N numbers, 5 G numbers, 5 O numbers, and you go to the cashier and you say, I want a Quick Shot bingo card. You get your bingo card, you look up, you daub, and you see if you've won. If you've won, you can cash it in. Courtney.
It sounds more like a reverse lottery. But yes, I'm sure that it counts as bingo.
How do you think it counts as bingo?
Well, I think yes, I think it probably does, because it's, instead of waiting for each number to be called individually, they're already called.
Yeah, I mean, it's clearly that's what the manufacturer of the product thought. Any other thoughts? How many people think it's bingo? 1, 2, 2, 3. How many don't think it's bingo? One, two, one. Well, let's take a look. And I will switch the share here. The NIGC has a process for you to submit games, and they will let you know whether they think it's class 2 or class 3. And here again, I stole the definition right from this PDF file. They define what bingo is, and I'll just read it out loud because it may be difficult to read. As described, quick shot bingo game does not meet the regulatory definition of bingo for several reasons. First, players do not cover their numbers when the objects are similarly numbered, or when similarly numbered are drawn. Instead, the winning numbers are drawn and posted on boards before players buy their cards. The players then compare the numbers on their cards with the posted numbers to see if they've won. Also, as it is being played in some instances, the game is not won by the first person to cover the previously designated arrangement. Rather, the game may be played for a set period of time, such as a week. The possible impact of such variations is that in the first instance, no one would win the game. In the latter instance, people could continue to play after someone else has already won the game. Therefore, quick shot bingo is not bingo under the regulatory definition of bingo. So normally the ball selection or the ball blower or the electronic facsimile of that selects numbers. You then mark them off, and then the first person to hit the pattern yells bingo and wins. Here, all the numbers are drawn in advance. They say that's not bingo. Looks like bingo, but it's not bingo. Let's go back to again. Looks like bingo, but not bingo. And the NIGC has lots of these opinions. So let's take a look at, well, let's take a look again. Bingo, at that definition that was cited, so 25 CFR 502.3. Notice this is what class 2 gaming means. Bingo or lotto, whether or not electronic computer or other technological aids are used when players, 1, play for prizes with cards bearing numbers or other designation, cover numbers or designations when the object or similarly numbered or designated objects are drawn and determined, and win a game by being the first person to cover. So there's your definition of what a bingo game is. And because the quick shot was a pre-draw game, it's not bingo. And because you could, for the other reasons I cited. So let's take a look at the NIGC site. We switch the share here. You see that? Is it showing up? Okay. So the NIGC actually has a website that shows all of the analysis that they've done on other games. So if you're representing a tribe or you're representing a gaming device manufacturer, this database is spectacular. Now, for a while, I had a small practice. A small part of my practice was in actually evaluating new games to give an opinion as to whether I thought, or provided an analysis as to whether I thought it was class 2 or class 3 gaming. And how did I do that? Well, I read through these and got a pretty good idea of where the NIGC stood. And then analogized game elements of the games I was analyzing to things that the NIGC has already analyzed before. So 121 different games the NIGC has analyzed. And again, if you look at the sort of the top row here, it'll tell you whether it's class 1, class 2, or class 3, whether it's a card game, whether the state has card games, and whether it's a pull tab. And then with, internet gaming is a hot issue. We'll talk about that in just a little bit. Let's flip the share back to PowerPoint. Sorry, my brain's been slow today. IGRA yesterday, slow today. So again, IGRA permits gaming on Indian lands. Now, there is a distinction between pre and post IGRA. IGRA defines Indian lands as all lands within the limits of an Indian reservation and any lands held in trust by the U.S. government for the benefit of the tribe over which the tribe exercises governmental authority. So again, kind of going back to that discovery doctrine, where the sovereign owns the land and the indigenous people have a right to occupy. Well, here they have a right to occupy and exercise governmental authority over the land, although the land is held in trust by the U.S. government. So lands acquired after the enactment of IGRA are generally gambling is generally not allowed on those lands, with some rare exceptions. One, the land is within or contiguous to the boundaries of the reservation. So occasionally you will see reservations where there are little pockets that are not part of the reservation that the tribe may acquire later. Other times you'll see that a reservation, when it was set up with a boundary that was water. So for example, a river. Now, over time, rivers move. I don't know if you've ever taken a geology class before or not, but rivers do move. And so you can end up with a situation where the boundary of the tribe was set at a certain location because that location had a river, and now the river's moved. Now there's a pocket of land between the end of the reservation and the river, and the tribe will acquire that. And again, it's contiguous to the boundaries of the reservation. Another exception is if the tribe had no reservation as of the date IGRA was enacted, and the land is located within the last recognized reservation within the state where it's currently located, provided that it's located in Oklahoma. Another exception. Land is taken into trust for the tribe, but the secretary determines that gaming on the newly acquired land would benefit the tribe and not be detrimental to the community, and the state's governor concurs. No good faith required. Those lands are taken into trust in the settlement of a land claim. The lands taken into trust are either taken into trust to settle a land claim, or for an initial reservation, or for the restoration of lands to the tribe that has been restored to federal recognition. Now, this has played out a few times. Hopefully we'll have Eric Dahlstrom talk about this in detail, but the one that's near and dear to my heart is this one. So in the state of Wisconsin, the Menominee tribe has a reservation in the northern wooded, lightly populated portion of the state. They would like to open a casino, but they want to open it in the southeastern corner of the state, which is pretty far from where they're located. They want to locate it in a place called Kenosha, Wisconsin, which is about 50 miles from Chicago and 45 miles from Milwaukee. So they want to acquire land in Kenosha for the purpose of putting up a casino in an area that's not contiguous with their current reservation. Because let's face it, they're in a rural northern county, sort of like Nevada. You know how many people are in Humboldt County, Nevada? Not a whole lot. So makes some sense. Now, the proposed casino will be located at a now defunct Greyhound track. And again, the closest tribal land is 175 miles or 170 miles from that track. So kind of give you an idea. Menominee are kind of, I don't know if you can see the pointer or not, probably not. But you can see where Lac du Flambeau is, kind of up in that area. Kenosha would be in the very southeastern corner. So you're in a huge population corridor. Again, a full-scale effort is put on to have that land taken into trust for the purpose of gaming for the Menominee tribe. And again, you need the governor's blessing and the secretary's blessing. So what happened? Well, what do you think happens? So if you've got to get the Secretary of Interior's blessing and the governor's blessing, what do you think the tribes are, what do you think this is going to, what's going to result from that? And no good faith is required. I should note that Ho-Chunk up in Madison have a casino, and the Potawatomi have a casino in downtown Milwaukee, by the way. So not everybody's too keen on the Menominee acquiring this and putting a casino up 50 miles from Chicago and 45 miles from Milwaukee. What do you think? What do you think ensues? So if you're the Menominee tribe, what are you gonna do? Courtney.
I'm going to lobby both the Secretary of the Interior and the governor about why this is going to be so great for both like the federal government and for the state.
Exactly. You're going to lobby like crazy. You're going to make sure that the congressman in that area is on your side and contacting the Department of Interior and pushing your case. And you're going to be lobbying the governor and helping to fund the governor's campaigns. And that's exactly what happens. Now, if you're the Potawatomi and the Ho-Chunk who are not too crazy about this idea, because Illinois tourists tend to go to their casinos, what are you going to do? Well, how about the same thing? And that's exactly what happens. The Ho-Chunk, the Potawatomi, start putting ads on TV. They've got their own people lobbying the Secretary of Interior. The Secretary of Interior, by the way, signed off on this. At the time, a guy named Paul Ryan was the rep, the House of Representatives representative from that area. He was in favor of it. Of course, he also was lobbied and had a fair amount of campaign funds thrown his way. So he was very active at pushing the Secretary of Interior to approve this, which the Secretary did. Now, for those of you that don't know it, Paul Ryan then went on to become a vice presidential nominee, and was, I think he was House Majority Leader at one time, or speaker. Might have been Speaker. Was he Speaker? Yeah. So that part, nominees were good with. But with the governor, you had both, you know, you had two tribes lobbying against it. You had one tribe lobbying for it. Both were funding grassroots citizens organizations to show why it would be so wonderful and why it would be so detrimental. And the governor at the time, and I can picture him, I can't think of his name. He was the prior governor. Was taking some time to figure this out. 3 election cycles worth of figuring it out. And he made his decision once it became pretty clear he was not going to get reelected. But in the meantime, there was some other fallout too. So part of the fallout was that the non-Indian developers of the first try at this hired a lobbyist that had some ties to organized crime. And for those of you that remember the George W. Bush years, there was a purge of attorneys, of federal attorneys that were not pursuing corrupt and criminal activities, particularly of those of in states where you had governors of the other party. And in Wisconsin, what happened is they went after the governor, the then governor of Wisconsin, a guy named Jim Doyle, for taking illegal campaign funds from the lobbyist for the Menominee, DG Entertainment. But the federal prosecutor brought the action either too early or there just was never any real evidence. And so the governor, the then sitting governor, didn't really face any issues from it. However, Paul Ryan did. And ended up giving the money that he had taken from those developers after the developer was convicted, and gave it to the Boys and Girls Club that was named after the developer that was convicted. They tried it again, but this time with the Seminoles' help. It didn't work either time. But it's an interesting process. It's, again, really interesting process. Something else we need to talk about quickly, and we'll hopefully get more detail on this with the guest speaker, still working that out, but our management contracts versus consulting arrangements. Now, IGRA requires the NIGC to approve management contracts before they're entered into or become effective. And the management contract must provide for accounting procedures, tribal access to daily operations, minimum guaranteed payments to the tribe before reimbursements, even for development costs, a ceiling on development costs, and a term not to exceed 5 or in some cases 7 years. Now, there are also limitations on the value of those contracts that can't exceed 30% of gross gaming revenue. The NIGC has 180 days with a 90-day extension possible to approve these contracts. If a contract is disapproved, it's null and void, and it can be disapproved if the NIGC finds that anybody involved has had a felony or gaming offense, has made a false statement to the tribe, or has, you know, some kind of prior activity or associations that are a threat. Now, the key here is that this is a measure to protect tribes from what was going on pre-IGRA, which was a developer would come in, I'll develop it, I'll give you guys 10% after I get my investment back, but, you know, I'll give you 5% until then as a down payment. Where the tribes really didn't benefit. Here, the tribes have to benefit. They have to be involved. And again, if you don't get prior approval of the NIGC, that management contract is void ab initio. Big deal, really big deal. Consulting agreements are a little different. Consulting agreements don't require NIGC approval, and IGRA doesn't actually mention them. So how do you tell the difference? Well, consulting agreements should be for a finite task, have dates of completion, and compensation should be based on hourly, daily, or some kind of fixed rate. Well, that's still not all that clear. So the NIGC actually has an advanced determination process. You can submit a contract to the NIGC to determine whether the proposed arrangement is a management or consulting agreement, and they'll let you know. Now, the danger here is, well, walk through an example. So let's say you're a bank and you loan money to a tribe for the construction of a significant expansion of their casino. Anybody ever have a bank loan before? Anybody ever work on a bank loan? Any LLMs here that have worked on loans or notes for clients? For those of you that have bank loans, what happens if you don't pay your loan? Courtney.
You get hit with fees and other penalties.
Okay, so I'm a business, I take out a loan, $20 million to expand my business. I don't make the payments. I don't pay the fees. I don't pay anything. What's the bank going to do? Well, usually for businesses, they'll sue you for it. And often what you'll have is a right to appoint a receiver to operate the business until the loan is paid back or a bankruptcy proceeding is initiated. So you don't pay on your debts as a business, that's the likely outcome. This actually happened, again, Wisconsin, to the Lac de Flambeau tribe. I think it was Lake of the Torches Casino. So they took out a big loan. I think it was paid for by bonds or whatever, and they defaulted. And so the bank sued them and requested that the court enforce the agreement, the loan agreement, and put a receiver in charge of the casino. What do you think the problem with that is? Well, the problem is that's a management agreement. If you have an agreement to run a casino, that is a management agreement. So what do you think the court did with that? Well, the court said, this is a management agreement. You don't have NIGC approval, which means that agreement is void ab initio. Bank, you're screwed. And I can tell you that the New York attorneys and the coastal attorneys that put that deal together and approved that deal were scrambling because their banking client was out tens of millions of dollars. It was either 20 or 40 million dollars. It was a big number. And it was a real big problem, and it became a big problem for banks. Again, historically, tribes didn't really have access to capital. But when Indian gaming took off, banks were tripping over themselves to do, deals with tribes because it was a pretty low risk activity. I mean, tribal casinos generally had a pretty high return. They were good pays. is a good piece of business. And unfortunately, a lot of banks just continue to use the same kind of forms that they had used before, form agreements. You start with a base and then you modify it. And in this case, court said no. That change in control provision there, that right to appoint a receiver, that's management of the casino. It's an agreement to manage the casino under these circumstances. That is a management agreement, needs to be approved by an IGC before it's effective. Therefore, you have no agreement. Now, the banks would then sue for unjust enrichment, of course. What it ended up doing is it ended up causing a lot of problems for the attorneys. And then the tribe and the bank actually had to work something out, because the tribe still wanted access to capital. They just hit a rough spot revenue-wise. Scope of tribal gaming compacts. Let's go back to that. These should be negotiated out, but generally they have lots of things that they identify. Again, authorizing the type of gaming, identifying the tribal lands on which the casino is going to be operated, construction requirements. Again, it's not in the state's interest to have shoddy construction. It's not in the tribe's interest either. But they should come to some agreement on those requirements. Inspection rights by the state, if any, information exchanges, workplace health and safety, taxation, insurance, employment law practices, licensing standards, patron dispute issues should be addressed, interplay with state regulations, gaming device testing. And by and large, this works pretty well. And it's worked out so well that this is the growth curve for Indian gaming. Now, it had a setback in 2020, like everybody did. But anecdotal evidence for 2021 and 2022 are that it's come back, just like it has here in most places. There are still some significant issues. One issue is what tribes can engage in Indian gaming. And according to the U.S. Supreme Court, only tribes recognized under the Indian Reorganization Act of 1934. So if you're not one of the tribes listed in that act, IGRA doesn't apply to you. Again, compelling states to negotiate in good faith. You had that states don't have to negotiate in good faith. State taxation. States can't disguise taxation as exclusivity payments. So they need to find another way to do things. Hot issue. Online gaming is a huge issue. Where does tribal sovereignty end? We've already talked about sort of that federal model where the bet occurs both where the bettor is and where the service provider is. That's been a problem for tribes, but there are some workarounds in some states. We'll talk about those later. Reinvestment and diversification are big issues in tribal gaming. And we're seeing that here. Anybody know who bought the Palms? San Manuel Band of Mission Indians. Anybody know who bought Mirage? Seminoles. Anybody know who's running the Virgin Casino? Mohegan. So they're diversifying. Now those activities in Nevada by those three tribes are not protected by IGRA. They're doing those as commercial ventures. But tribes are also investing in other things. They're using gaming revenue to invest in, there's a tribe in Washington that's reinvesting in timber and in renewable resources, renewable energy. Sports wagering has been a big issue for tribes. Competition between tribes, big issue. And federal representation. We've got the first Secretary of Interior that is of Indian descent. Deborah Haaland is a Laguna Pueblo, first time ever. So big. I mean, in Indian country, this is huge. So it was even those that might not be, from tribes that are not maybe close to the Laguna Pueblo, we're most are pretty pleased. So that's kind of a real high level overview of Indian gaming. Hopefully you can see where this came from. You'll have some footing so that when we do start getting guest lectures on specific topics in Indian gaming, you'll have some kind of foundation for understanding what they're talking about. Again, we'll have specific reading assignments for each guest lecturer. I'd encourage you to read those assignments when they come out. One thing I will say for those looking for work, Indian gaming is still an expanding area, and there aren't that many classes nationwide on Indian gaming, and you're going to be in front of people with some influence in Indian gaming. It wouldn't hurt to make an impression. We've had a number of students that have been hired by tribes. In fact, we have one that was hired by the NIGC. So, it's worth knowing. It's worth getting familiar with. It could result in some positive career movement for you at some point in time in your career, maybe early, maybe later, but knowing won't hurt you. If you can understand where the tribes are coming from, if you understand their issues, if you understand how this is different than commercial gaming, I think it can go a long way to helping your career. And even if it's not with tribes, it might be with manufacturers or people who provide services to tribes. Yeah. I can't tell you how many, especially with sports wagering, and the number of foreign sports wagering service providers that want to do business with tribes. I've been consulting on a number of these, and I've each time told them, submit the document to NIGC for approval or for determination as to whether it's a management agreement or not. They're like, oh, we don't have to do that. I'm like, well, you don't do that, you might have no agreement. And if you're planning on installing all sorts of equipment there and investing there, you might want to make sure your agreement is enforceable, is an agreement. So even if you're not representing the tribe, and by the way, the tribal representative said, yeah, you need to do that. That's a good idea. That's a really good idea, but that's your problem, not ours. Which it is. The tribal submitted on your behalf, but if it doesn't happen, like the Lac de Flambeau, oh darn, we have $20 million that we don't have an obligation or contractual obligation to pay back at this point. Oh, the horror. It's on you. So getting familiar with that I think is helpful.